Mr. Notes.
Afternoon, Judge.
Afternoon, sir.
Judge, I've got Mr. Casey. He contacted my office over lunch and said that he had been here and somehow we didn't. I know I went outside to call. I don't know that I called out in the courtroom, but in any event, I'd ask the court to consider recalling the warrant. And we talked about setting it for September 12th in hopes that we can maybe get something worked out. I just got appointed on the 15th of June.
We can either do that or just do it on, have a regular pretrial, and then if you get something done, set it either way. Why don't we just set a regular pretrial and then?
That's fine, Judge.
And Mr. Casey, it was confirmed. The bailiff confirmed that
Yes, sir.
you were here, and it's weird, and we called the name and you probably weren't, weren't thinking, and Mr. Notes walked outside and walked past, is like a perfect storm.
I'd never met him, so I mean,
We'll have one more.
And
absolutely.
we're not trying to jam people out there. People do enough to get themselves in trouble, and we're not trying to jam people up and put them in jail and stuff, as much as it may otherwise seem like it sometimes. So we'll come back on October 9th, 9 a.m. If you get something worked out, we'll get it on we've got several miscellaneous days before then, we'll get that on.
Yes, sir.
Very good, Judge. Thank you so much.
Thank you. Okay.
Have a great day, Judge. I
Thank you,
appreciate
Mr.
that.
Notes.
There's 2 out of custody as we wait on Mr. Medina, and the rest are in custody.
See where Mr. Medina is. Ask him how long it's going to be.
Hey, Tevin, can you ask Mr. Medina how long he's going to be? The judge is asking. He just wrapped up.
Okay. Then we'll wait.
He's on with that.
Who do you want to call first, Mr. Medina?
Probably the female inmate, Victoria Berube, that we have an agreement for, Your Honor.
Okay.
Tevin, we're ready for Victoria Berube.
And if it helps the court to, or it helps the courtroom security to call all the females, there's another female For me, Nina Cox. I don't think we're... I think you need to talk to Miss...
Yeah, we need her one more time.
Just bear with me a second. I just want to make sure I give probation a copy. Actually, not necessary because it's straight jail. Okay. Your Honor, Steve Medina with Victoria Lynn Berube in 23 CF 1344 and 23 CF 1222. The state has signed the agreement that's been worked out between the parties, and I've gone over it with Ms. Berube, and she is signing it now, Your Honor. Thank you. 8/21. Yes, ma'am.
Thank you very much. Thank you. Thank you.
Yes, ma'am.
Thank you very much.
Okay, don't go anywhere then. We're gonna see if the judge will take the deal. Ms. Sharper, Steve. Your Honor, may we approach with the... May I?
Thank you. You okay with the score sheet?
I apologize, Judge. I do need to show it to her. I'm sorry.
It's all right. You're good.
Thank you for asking that, and I'm sorry for that. Okay, Steve. We're okay with the score sheet.
Thank you. Could you please announce the plea agreement?
Yes, Your Honor. Your Honor, under the terms of the agreement, Ms. Berube will be having an adjudication of guilt as charged in these two cases, 9 months concurrent Okaloosa County Jail with credit for all time served, and with credit in the first case, the lower number case, 23 CF 1222, to include all time served in 23 CF 1344. In essence, her bond wasn't immediately revoked in the first case when she picked up the second charge, so the state is giving her credit of what she thinks is about 9 days served in the second case. It would also apply to the first case. 515 court costs times 2, 250 public defender fees, outstanding monetary obligations to collections 12 months after release.
Very good. Ms. Berube, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, I do.
So you heard your attorney state the terms of your plea agreement,
Yes,
and that's saying the same terms are contained in your written plea agreement that you have signed. Did you read this closely?
I
And
did.
you went over it in detail with your attorney, made
I
sure you had
did.
all your legal questions answered.
He did.
And importantly, you understand you're waiving some valuable legal rights.
I
The
do.
right to go to a trial. This will be a final adjudication of your case. Do you understand that?
I do.
You believe it's in your best interest to enter into this today?
Yes.
Okay, do you have any further questions, legal questions of your attorney
No,
regarding
not
this
at all.
plea? Okay. Based upon that testimony, the court will accept your plea agreement. There'll be an adjudication of guilt in both charges as charged. You will be sentenced to 9 months in the Okaloosa County Jail on both charges. They will be served concurrently, so at the same time. You will get credit for all time served, with credit in the newer case, 23-12-222, will include all time served in 23 CF 1344. Standard fees and court costs, you'll have 12 months after you get out to pay it before it goes to court.
Okay,
Any
thank you.
questions?
No, none at all.
Very good. And you do have 30 days to appeal this, even though it's just been entered into a plea agreement. You do have 30 days to appeal. Thank you, ma'am.
Thank you.
Mr. Medina?
Ma'am?
Can I just state play tournaments on that critical time served for both cases?
No, the reason why is because the state wasn't giving her credit for whatever time she did in the first case and the second case.
Okay.
I'll write it.
And that might, I don't think was a lot of time, but it's technically a different date. But at least when she got picked up in the second case, and for whatever reason at first appearance, the bond wasn't revoked immediately in the first case, at least she would pick up those days.
Would you announce this case?
Yes, Your Honor. This is Nina Cox. Ms. Cox is before the court in 22 CF 3023 and 19 CF 1465. If the court will permit, there is good reason to believe we may be able to resolve both these cases, but the state needs 2 or 3 more days. Is it possible that we could bring her back for a plea or continue on jury review? I hate to load up on that 9 a.m. on August 24th.
So, no, that's fine. We'll continue until jury review 8/24 for a plea or continue.
Thank you, Your Honor. And Deputy By, after this, it's just whatever's most convenient to you. And I just figured the females would go.
Did you want to add anything about your outer custody? Are they going to wait?
We can do the out of
Yeah,
custody.
let's do the out of custody and then we'll do all the inmates.
Okay, let me just get my bearings on who the out of custody are. So I know we've got Mr. Borum.
Okay, let's do Mr.
Mr.
Borum
Evans.
first. Alonzo Borum,
Yes, Your Honor.
and that is 22 CF 1169.
Your Honor, we have an agreement that I've written up. I just want to confirm. You're good to sign the agreement, right? If you have any questions. I do need to get Ms. Sharpless's final review and signature, Your Honor.
Okay.
But it contains the terms that the state was willing to agree to. What? No, I'm not. That's it. That's good. I did.
Steve, I had an ashtray champagne.
Well, that's how we got to the lower number.
No, I just missed the possession charge stuff on it.
Yeah.
It must be a weird one.
What's more? Okay.
Your Honor, I do need to make one change. She's not She didn't change the outfit. She did the math. I didn't have benefit of her score. It still comes out to this, but you would be as charged on the fleeing relief. And that's her position.
So, I would be.
Three and four.
To
Right. I had that. So it's the same bottom line. 2, 5, 6, and 7 as charged. It's the same result. That's the same position. I'm looking at her score sheet. She's got it correct on the score sheet. That's what it is. If you want to come back. I just can't take all the time. You want to sit down? You want to sit down? Huh? Look, man, you can sit down and I'll try to explain it to you when I get a chance, okay? But that is the score sheet. That is your offer. Huh? Okay, so. That's okay. So, yeah, counts 1, 2, 5, 6, and 7 as charged. Yes. I had done the problems, I had done drawings, yes, I got to that number.
Sorry, I should have sent you.
That's okay. Do you have your score sheet? Do you have your score sheet?
Well, I know, but I'll tell them what the number is and I can print it out.
Okay.
I tried to.
But it's the 55.9,
55
and it completes to the 20.925.
Yes, that's what I have.
Okay, all right. Your Honor, may I approach?
You may.
I actually need to make a copy. Thank you for your indulgence, Your Honor. And I'm sorry this is handwritten.
Okay.
Your Honor, under this agreement, if I could just give a brief overview, is Mr. Borum really wants treatment. In fact, while this is a plea to the bench agreement, while that is pending, he anticipates in Georgia entering treatment in the next day or two. Is that about right? Okay. Under this agreement, he would be pleading out 22 CF 1169. The state is agreeing to dismiss counts 3 and 4 in exchange for the following. And I would just note 3 and 4, the state did not get Florida Department of Law Enforcement chemical analysis to back up those charges. The defendant would be pleading to the bench on counts 1, 2, 5, 6, and 7 as charged. And of those, only counts 1 and 5 are felonies. Counts 2, 6, and 7 are misdemeanors. And Your Honor, there's an asterisk. I ran out of room. Count 7 is at the bottom, the paraphernalia.
I see that.
It would be a cap of 20.925 months concurrent DOC with credit for all time served. There would be no cap on supervision. Your Honor, a long time ago, he represents to me he had an escape charge when he was a teenager from a juvenile camp that is no longer in existence. So he actually wants the court to have some background that might come out through a pre-sentence investigation, which the court might enter anyway. So we're asking that there be a pre-sentence report, if the court's okay with that. And we're also asking that, I think it's routine that to consider that might take up to 45 days or something like that for the report. I don't know if that's exactly right, but basically, he's going to be getting treatment, hopefully, during the interim. So he'll have to get released from his treatment to come to a sentencing hearing. But I think he's trying to put the facts in as good as posture as he can for sentencing. And that's the situation, Your Honor.
Very good. State in agreement?
That is a state's agreement, Your Honor.
Okay. Mr. Borum, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
Okay, so you heard the attorney state the terms of your plea agreement.
Yes.
And I see those terms are also contained in the written plea agreement that you've signed. Have you read through this thing closely, the plea agreement?
I did.
And did you go over it in detail with your attorney, had some candid discussions and ask him any legal questions about the plea that you need answered?
Yeah, I did.
Okay. And you're comfortable that this is in your best interest here today?
Yes, sir.
You understand by entering this plea, you're waiting there to go to a final trial and contest all these, and this will be a final adjudication. Now we're pleading to the bench, it'll be a final adjudication of the underlying charges. But it's not a final agreement on the sentencing because you all didn't agree on what the sentence should be. That's the part that goes, quote unquote, to the bench. You understand that?
Yes, sir.
And based on my calculations, taking into account the two charges that were dismissed, 15, 16, 21, 22, 23, based on my calculation of 23 years max. Do you understand that?
Well, Your Honor, it's going to be a cap of 20.925 months concurrent.
That's true. That's true. Thank you for reminding me of that. It's been a long day.
The court is just making sure you understand, as it could have been, as the court is saying, if we didn't have.
Actually, I misspoke. I always want to make sure that when you're pleading to the bench, that you understand. Everyone looks at the minimum guidelines. They think that's the sentence. Whereas oftentimes on a plea to the bench, there's much higher numbers that are involved, potentially. I may come back and say, yeah, you need a second chance, and I'll put you on probation. I don't know what I'm going to do now. And I agree with your attorney that we need to have a PSI. I'm always open to having a PSA. The more information I get, these are the most difficult decisions judges make who are criminal judges. I want to try and get as much information as I can to try and make a fair, honest decision, okay? So, you understand all that? You had all your questions answered?
I do.
You understand how the plea to the bench works? You got the cap of 20.925, not 20, whatever I just said. 20 months, less than 2 years is your cap. Now, I can add some supervision on top of that, and that's probation, okay? You understand that? Very good. Based upon that, the court will accept your plea. Court, and the state's in agreement with this, right? The
Sure.
dismissal of
This is-
counts 3 and 4.
Yeah, sure. This
Court
is-
will dismiss counts 3 and 4, and as to the other counts, court will do a plea to the bench. They'll be adjudicated, they're not guilty, but there'll be discretion whether to withhold or adjudicate. Cap of 20.925 months in the county, in the Department of Corrections, and all those would be concurrent, so it's a total 20.925. You will get credit for all time served. No cap on supervision. Okay?
Your Honor, to make it easier for probation on the pre-sentence report, if Mr. Borum will make sure to give probation his phone number or any other contact information,
Okay.
so they can do their best to stay in contact. And if you do get in treatment the next day or two or whenever prior to being sentenced, make sure that you let them and me know where you are, okay? Thank you. Thank you, Your Honor.
Thank you.
And the date for sentencing,
Yes, we need a date for
Oh, I'm sorry, we got it, Mr. Borum, we got to.
Well, we don't know, because we're coordinated through the judicial assistants.
Okay.
So if you'll call and get that done.
Yes,
we'll get it
sir.
on.
Yes, Your Honor. Let me make note to do that. Thank you.
Control date, Your Honor?
Sure. We'll do a control date for, just our next pre-trial, but that won't be our control. Just do it pre-trial.
Just the status?
This step.
Okay.
And Mr. Borum, I can do a waiver of your appearance for that if need be, but it's important that you remain in contact with me and probation, okay?
Yes, sir.
But it's because we're going to be getting a sentencing date that has to be determined. Okay, thank you.
I'm okay.
Thank you. Yeah, you're free to go. But give them your phone number. Your Honor, can I call Mr. Michael Evans?
You may.
Michael Bernard Evans. Your Honor, may I just give him a quick bit of information?
You may.
Doesn't want to have, it sounds like she's probably okay in jail, okay? But there's a lot of money that's owed. I'm going to ask her if she won't let it go to lien, okay? She doesn't want to go to lien, but you don't want to be on probation. I'm going to see if she'll do administrative non-reporting probation. Okay, you. Okay, Your Honor, Mr. Evans doesn't look like we're going to reach an agreement today. If we could continue his case to October 9th for pretrial, and then he could set an appointment with me in my office to go over his case.
Very good. We'll continue till October 9th, 9 a.m.
Thank you, Your Honor.
Yeah, we'll set an appointment. That would be good. Do you not have my card? Okay, then I'm not sir, I can't. You called at 7 point.
John Chapman?
That's me. What's that then?
Your Honor, Steve Medina with John L. Chapman. I filed a motion for bond. Does the city have the motion for bond that I filed?
Did you file it?
It was probably Friday.
No, sir, I don't.
Okay. Your Honor, it was noticed for today. In essence, without addressing the bond motion for just a second, is that Mr. Chapman has a probation offer from the state, but it would require him to be pleading out to some things that he had told me he didn't want to plead out to, that he wanted to oppose the charges potentially at trial. So he was asking to have his, basically his bond reinstated. May I provide my copy of the bond motion to the state, Your Honor? It's just real short.
Sure.
Your Honor, may I just proceed with the bond motion?
Sure. I haven't reviewed it though, so
Okay.
you're gonna have to
Can I
lay it out to
does
me.
this court have access to it in the? I'll approach with my copy, Your Honor, if that's okay.
Sure.
Okay. Your Honor, Mr. Chapman was out on bond, and then he picked up a misdemeanor case, 23 MM 1884. When that occurred, his bond was revoked. My understanding from him, and I do want him to testify to this, is that he has some really serious medical issues that require him to be hospitalized potentially and potentially have surgery, other medical needs that he contends aren't being addressed. And that also, he also represents that he does have very good housing and social services type support. So without talking about the facts of the case that's pending, I was hoping he could be sworn and address those two issues, Your Honor.
Would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
So help me God.
Mr. Chapman, do you have, what is your name?
John Leslie Chapman.
Okay. And just kind of take it in reverse order, but do you have a local address?
I do.
Okay, and
I
you
live at-
live with a family member?
I live at Bridgeway Apartments,
Okay.
and I've been there 4 years, but I'm a volunteer for the state of Florida. I've been in Destin for 48 years.
Okay.
So
Okay.
I've been here on the coast for a long time.
And as part of your Bridgeway apartment, do they also make sure that you get proper social services
Absolutely.
and
Absolutely.
psychiatric treatment? And so forth?
Absolutely. But I've got an open heart surgery coming up
All right,
sometime.
well, let's address that.
Okay.
That was the first issue. What kind of medical issues do you
Yeah,
have?
I was diagnosed with an AAA, which is a AAA aneurysm, fibia. And they don't know really what's going on with it, but I'm way past due of getting another ultrasound. So I've got to go back to the hospital, and they got to do it. If it's growing, they're going to have to. I had open heart surgery 10 years ago.
Let me ask you one other thing. Without talking about the facts of either the misdemeanor case or your original case here,
Mhm.
without talking about that,
Mm-hmm.
if you were to get your bond reinstated, or this court give you a signature bond or some other bond that you
Absolutely.
can make, how much bond could you make? Is there a cash
Well,
bond that you
I'm
could
not
make?
going. I'm not going anywhere. I've been here for 50
Well,
years.
are you able to pay any kind of cash or professional bond?
Sure. I don't know how much, but I could. You know, I'm on Social Security, so I only get $800 a month,
All right.
and my bills are
Okay,
$1,600.
all right. I'm sorry, but the really the last question I wanted to ask was, again, without talking about your charges, but if you got out, would you give the court your word of honor that you will not drive?
Absolutely.
Okay. No further questions, Your Honor.
Your Honor, in this case, the defendant is charged with aggravated assault on a police officer, fleeing and eluding, and it is the felony second level 4 fleeing and eluding, so it's in a vehicle with lights and sirens activated at high speed. And he's also charged with DUI, Your Honor. He was caught speeding, going 8 miles per hour in a 35-mile-per-hour speed zone. He almost caused a crash, which led to the police making contact with him. He, at the time of that crash, when the police were trying to pull him over, he was making quick turns towards the police officer's vehicle, putting the police officer in fear that Mr. Chapman's car was going to strike them and cause a potentially deadly accident. He did not stop his vehicle for approximately 4.17 miles, according to the arrest report, Your Honor. And then at the time that he was taken into custody, there were also indicators of impairment in the case, Your Honor. Then he was given a bond on that case. Then he was caught driving again on a suspended or revoked license, and that's what placed him on no bond in this case, Your Honor. So given that Mr. Chapman doesn't seem to be, is out on serious charges, that put the community at risk, and that he doesn't seem to be able to follow the most basic rules of a bond, namely not getting a new charge and not driving on a suspended license. I don't think that there are conditions that the court should reduce his bond. I don't think there are conditions of bond at this time he'd be able to follow.
Do you have a motor vehicle? Were you driving your own motor vehicle or driving somebody?
Absolutely. Fully insured.
That's not good, actually.
I know.
I was hoping you wouldn't say that.
Well,
You don't need to be driving, not now.
okay.
Not while you're out on bond.
I got you.
Your
Is
Honor,
the state, no, let me ask a couple, I'll give you a chance to talk some more, but let me ask the state. So what's the state didn't address Mr. Chapman's concern over needing open heart surgery or serious surgery dealing with an aneurysm. And so am I to assume that the county's ready to go on that? That they're ready to have that surgery? Is that what, or do you? Yeah.
Your Honor, all I can address about that is I'm unsure. I don't know the extent of how badly needed this surgery is. I don't know if it can wait. I don't know if he is able to have a surgery inside the jail. I don't know if we gave him a furlough to go get the surgery and then brought him back to jail. I don't know what the situation would be then. I don't have enough information to address that.
Can we get that information? We have a very serious thing. There's no doctors that I see in the courtroom. A couple of the bailiffs might be able to do emergency procedures, but other than that, I certainly can't. But
Judge, I don't have a problem.
I know what an aneurysm is. I know what an aneurysm is. Aneurysm goes south.
You go with
We
it.
won't be worrying about his criminal charges.
Your Honor, I can call the jail and find out.
Yeah,
if
why don't
this-
what I would like to do is to get a little more information. Find out all those, so you asked about 6 or 8 questions, or you said you didn't know this and this and that, all were wonderful. Can you have a furlough? How long is it going to take? How serious is it? Can they do it? What's their position? Do they want to do it, or are they going to do it? When are they going to? All those things, those wonderful questions, and I think they need to be answered. How long would it take you to answer those questions and to come back? We don't necessarily have to do it for jury review, but we can. Let's see.
Usually the jail would know within a brief period of communication, Your Honor. They're usually on top of those things.
I could ask them to contact me, Judge, but we'll be here tomorrow as well, so I don't
Yeah,
know
no.
that. Mm-hmm. Yeah, miscellaneous tomorrow.
You didn't know that?
Not right now, Judge. I'm just going from one day to the next. I don't know.
I think you're going to be here. I hope you are anyway.
You say so.
I think we have a break on Wednesday. I don't know if you
We
want.
do have a break on Wednesday. You
Yeah,
got a free
I
day.
could try on Wednesday to have Captain McDaniel or someone at the jail call.
Yeah.
Why don't we come back on the 24th in the afternoon, not for jury review, but we have miscellaneous docket.
1:30, Your Honor?
Yes. See if you can figure that out. Do you not know that?
Yes, sir.
So come back and answer some of those questions.
Yes, sir.
The other thing I'd like to know is if the court was trying to make an accommodation for this defendant, what would be the additional requirements of a bottle? For instance, a scram.
Yes, Your Honor.
I don't know what we can do with his
GPS.
vehicle. Can we impound his vehicle? Because he definitely doesn't need to do it. You definitely don't need to be driving for a while.
Vehicle sitting in Bridgeway Park where I live at.
So, anyway, let's come back on the 24th and let's look at. We need to at least look at it because
I've already.
if you've got a medical procedure that you need, then somebody's probably got to do it, or at least we need to be talking about it.
Yes, Your Honor.
In normal circumstances, Ms. Sharp, I don't know that we need to do this. Based on, this, under normal circumstances, I wouldn't be considering letting you out on bond right now, based on what's happened. Except for the fact that you may need surgery in order to stay alive, and we have to.
I definitely want to stay alive.
We definitely need to be human beings as well as justice. Okay, so we'll come back on the 24th.
Thank you, Your Honor. Thank you, Steve.
Yes, sir.
Thomas Blankenship?
Your Honor, Thomas.
I'm sorry, wrong order. It's actually the very,
Yes, good. Tavares Allen, yours before the court, Your Honor. Tavares L. Allen and 23 CF 1271 and 23 CF 1292. And I don't know if Madam Clerk has the VOP case on the same docket, but that's 22 CF 1362.
Yes, sir, I have it.
Good. Yes, we do have all three cases. That's docket numbers 62 and 62, I think. Your Honor, we have an agreement.
Yes, and you're not, we're just going forward now.
Just take that. Okay. I'll let you have my copy. May I approach, Your Honor?
You may.
We have an agreement and score sheet, Your Honor, just making sure that I sign it.
As Ms. Gooden did a continuance. I should continue to,
Thank you.
Continue on number 7, number 8, will not need to be seen here.
Your Honor, due to the agreement, Mr. Allen will be adjudicated guilty as charged. He would admit the VOP in 22 CF 1362. There would be revoke and terminate on that supervision, 14 months concurrent DOC with credit for all time served, $100 VOP fee,
So the 14 months concurrent DOC is for each of the three, the felony VOP and the two other,
That's correct, Your Honor.
okay.
Yes, Your Honor.
They're all, it's a total of 3 felony charges, including the felony VOP, and they would all be 14 months concurrent DOC with credit for all time served. Now, that I've explained to them, they're going to have different credit.
Right.
Because he did, on the 22 CF case, my understanding is he did 1129 jail or thereabouts. So he has a lot of credit on that case, but he would like it applied in the 23 CF cases, but I don't think that he's allowed to get that credit.
It's not the way it's generally calculated, but we don't
Unless
do
the
we
state
don't-
allow it to get that credit? No, the state will not allow that credit. $100 VOP, 967 court costs in 23 CF 1271, 515 court costs in 23 CF 1292, 350 public defender fees, monetary obligations to collections 24 months after release, Your Honor.
And Your Honor, this is a downward departure. That is the state's agreement. I did discuss that with the victim of the victim of the 23 CF 1271 offense, which is the new felony battery. He was on board and understood why the state was offering that. And Your Honor, the alleged, it's not, the docket says possession of weapon or ammo by a convicted felon, but actually the state has charged carrying a concealed weapon by a convicted felon, which makes it from the misdemeanor to a felony. The alleged weapon was a pair of brass knuckles, and there may or may not be some equivocation about whether he knew that was illegal for him to have, Your Honor. He knew about firearms, but he was equivocating whether he knew that that weapon was legal for him to have. So those are the reasons for the state's downward departure.
Okay. Mr. Allen, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard, by the way, is the score sheet okay for the defense?
Yes, Your Honor.
And Mr. Allen, you heard your attorney state the terms of your plea agreement. I see those same terms are contained in the written plea agreement that you signed. Did you read this plea agreement closely?
Yes, sir.
And
Yes,
did
sir.
you go over it in detail with your attorney, make sure you had all your legal questions about this, how it works and
Right, sir.
all that?
Yes, sir.
And you understand you're giving up some valuable legal rights by entering into this, the right to go to a trial, force the state to prove their case, all that, you're saying, no, we're waiving that one and get a final resolution of this case.
Yes,
Is that what you're doing?
Yes, sir.
Do you believe it's in your best interest to do that?
Yes, sir.
Nobody threatened or coerced you to get you to enter into this plea?
No, sir.
Okay. Based upon that testimony, the court will accept your plea. There'll be an adjudication of guilt on the 2 new law charges and an admission of the VOP. On the violation of probation, the court will revoke and terminate supervision, so probation is finished, and sentence you to 14 months DOC. The other 2 cases, I'm also sentencing you to the exact same 14 months DOC. They'll all be served concurrent, same time. So it's basically a total of 14 months. You will get credit for all time served on each individual one, but as your attorney correctly explained, that they can be different calculations. Those calculations are actually not made by the court, they're made by the prison system.
Yes, sir.
So, in addition, there's a number of court costs and fees that are contained in here. Those can be paid anytime, 24 months after the release, or it goes to collections.
Your Honor, may I ask one other thing of the court? Would the court consider allowing Mr. Allen to get drug treatment while he's in DOC?
If it would be helpful to make some mention of that in the sentencing, I don't know that I can order substance abuse, but I think, what do you do? You
I
make
think
a
on- I think if-
recommendation or?
Yes, I think if the minute sheet state that the court is not objecting to him going to a facility where drug treatment is available.
I'll go
that-
as far as to say the court would think that it would be a good idea.
If
You think you need it,
Yes,
then
sir.
If that would be reflected on the minute sheet, Your Honor, I think that would help do.
What needs to be reflected, I was trying to get the
No, no.
information straightened out.
That's-
The court supports defendant receiving drug treatment
while in
while in
DOC.
DOC.
Yes, sir.
Sorry, Your Honor.
That's fine, that's good, it's
Well, I
important.
wanted to be clear because the information says carry concealed weapon by convicted felon, but the statute we have as possession of a weapon by convicted felon. Is that okay to have that? Because I'm concerned about this information now. When she brought up.
It's very good for you to clarify, Madam Clerk, and I appreciate you doing that. We need to get the right statute number and the right title.
Well, I can tell you that they're the same level and degree, Your Honor. I just think maybe my office provides clarification on the information, but I think it is the same statute.
I see that the information matches the score sheet and indicates that the charge of carrying a concealed weapon by a convicted felon is the charge in 23 CF 1292, and it's a second-degree felony level 5, right?
Yes, and Your Honor, it is the same statute. Madam Clerk, that's the right statute number. It's 790.23.
So what he was arrested for in your arrest report, you amended it with your information.
That's correct.
To clarify that it was a weapon and not a firearm or
Yep.
ammunition, and I think that's why my office does that, Your Honor.
It is
to
a
make sure.
different charge than what was originally charged. The information is different. That is absolutely correct.
Thank you.
Okay. Good
Thank you,
luck.
Madam Clerk.
Thank you, sir.
Thank you.
Well, I think it's the same statute, Judge. It's just clear, and my office clarifies that it wasn't a firearm or ammunition. It was a weapon, a concealed weapon. That way the court.
Mr. Medina, this is your motion for bond. I just wanted to-
Yes, sir. Yeah.
Mr. Chapman, sure.
Thank you.
Yes. Thank you.
Your Honor, Charles Bernard Alvey is before the court, docket 63, 23 CF 629. I wish there were, my family doesn't wish there were two of me, but I wish there were two of me because I could write up Mr. Alvey's agreement that he wants to take, but I just haven't been able to type it up. But we've reached an agreement. I'm hoping we can set him aside and maybe on a quick break I could write it up, but we have a resolution.
You're all that's remaining, so however quick you can take a break.
It expires to everybody, understands that.
Yeah, that's fine.
Okay.
Why don't we go as far as we can?
Oh, the state points out it's bars to bed, So what's the facility you're going to be going to? What's it called?
Master's Touch.
Where is it?
That's cool.
It's in Pensacola?
Yeah.
Okay, so,
You want to, we can come back in the afternoon on juror review and plead that's another miscellaneous, that's
that would
3
be the
days.
maximum time, and you'd be able to let them know that you're pleading out on Thursday so that they could have a bed available.
I've already read the bed. I already have the bed waiting for
I
me.
mean,
They're ready?
Yeah.
I'll wait, I'll come back today.
Judge, I'm sorry to ask, but I'd love to get somebody out of jail a couple days early. So if we can send it back, I will write it up. It won't take long.
And we will need a GPS before it's released.
Yeah. You're gonna have to wear a GPS. Okay, Your Honor, I'll do my best. I'm sorry for that delay.
So let's just get, we'll get the rest of them cleaned up, and then we'll take a break this afternoon, and we'll come back and
Yes, thank you, Your Honor.
Mr. Blankenship, thank you.
Your Honor, Thomas Carl Blankenship for the court in 23 CF 68. And we have a misdemeanor resolution in his case that will not require a score sheet. Thank you. May I approach, Your Honor?
you may.
And I need to pull out my copy. I apologize. Your Honor, under the terms of the agreement in 2368, Mr. Blankenship would be adjudicated guilty to a misdemeanor simple battery, first-degree misdemeanor. Madam Clerk, the statute references in there on count 1, so it's a lesser-included offense, simple battery. And to count 2 as charged, which was also a misdemeanor. Credit for time served, 622 court costs, 150 public defender fees, monetary obligations to collections 6 months after release. Those are the terms, Your Honor.
The parties approach. You can start if you want. I just was kind of wondering what's going on here. Just for fun. Okay. Mr. Blankenship, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Judge.
Okay, so you heard your terms of the plea agreement. You can put your hand down. That your attorney just made, and it's contained in the plea agreement. Can you sign that plea agreement?
Yes, sir.
Did you read this thing closely?
Yes, sir.
Did you go over it with your attorney, make sure you understand all the
Yes,
all the
sir.
legal ramifications, and had all your legal questions answered? You
Yes, sir.
understand you're waiving the right to go to a trial to be a final adjudication.
Yes, Judge.
You believe it's in your best interest to enter into this.
I do.
Very good. Based upon that, the court will accept this plea. There'll be adjudication of guilt on both of these misdemeanors. One is a simple battery, so the lesser included. The statutory cites in here in count 1. Count 2 is as charged. You'll receive credit for time served on both of these. That'll be your sentence. you'll have court costs and fees that you'll have 6 months after you get out before it goes to collections.
Yes, Judge.
Any questions?
No, sir, thank you. Thank you for your time.
Thank you.
Thank you, Mr. Medina.
Governor Steve Medina with Christopher Ralph Bobbin in 21 CF 917, 21 CF 993, 21 CF 152, 23 CF 657, and 23 CF 667. Mr. Bobbin is asking the state to consider an option for resolving his case that would involve a split sentence, and the state is thinking about that, and he would, in essence, propose a 1129 jail, followed by bars to bed Keaton. And the state is looking at the situation. If we could bring him back, do you think we need a full cycle on October 9, or do you think we could resolve it before then?
We could try for September if we wanted to.
September. Your Honor, is there a date in September miscellaneous that we could bring him back?
We do. We've got, where are we at on the 19th? We can do it September 12th or the September 19th, either one.
The 12th sounds good, Your Honor.
12th?
Yes, Your Honor.
September
9 a.m.,
12th.
sir?
9 a.m.
Thank you. All right.
Thank you.
Yes, yes, sir.
Can I ask you something real quick? Kind of busy. Oh, did you figure out what the judge had? Okay, thank you.
Caleb Boone.
Your Honor, Caleb Lincoln Boone is before the court, docket 6822 CF 2779. I was hoping we'd have a plea today, agreement. May I just inquire with him? Your Honor, I think we can reach an agreement today that would resolve his case. I will need to send it back to him. I apologize. Could Mr. Boone step back briefly?
We will, we're going to have to take a break anyway because there's a couple cases like this, so we'll go as far as we can. We'll take a break and deal with it.
Okay. Thank you, Your Honor. I'll be back to see you in a few. Your Honor, Alexander James Boss is before the court, 22 CF 800, 23 CF 676, and 23 CF 677, and he is signing an agreement for a plea to the bench. And the state can announce what the score sheet would show, but we normally provide that at the sentencing hearing, Your Honor. And we're, in essence, he's being capped at that number.
That's the minimum guideline.
Yes, Your Honor. It's Alexander Fawcett. I'm just going to get a spare copy for probation, Your Honor.
Mr. Boss, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide to this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of your plea agreement.
Oh, you're I'm sorry, Your Honor, I haven't stated it yet.
Said you were pleading to it with the cap, but I guess you weren't, you had a little more
I didn't
detail.
really set it forth.
Go
Your
ahead and
Honor.
lay it out in detail.
Yeah, I'm sorry.
Sorry.
Under the agreement, 23 CF 676 shall be dismissed, and it was duplicative of the charge in 22 CF 800. There would be an adjudication of guilt as charged in 22 CF 800 and 23 CF 677. And defendant does plead to the bench with a cap of 12.6 months DOC with credit for all time served and with no cap on supervision. And Your Honor, he has been accepted at Phoenix House.
Yes,
and is
sir.
hoping you'll get to go to Phoenix House, Your Honor. That we don't have an agreement with the state on that, but the state has agreed to have a cap of the guidelines.
Very good. Mr. Boss, would you raise your right hand? Yeah, well, I already swore you. So you heard your attorney state the terms of your plea agreement in a little
Yes, sir.
more detail.
Yes, sir, I
And
did.
it's contained in the plea and sentencing agreement that you signed. Did you read this closely?
Yes, sir, I did.
And did you go over it in detail with your attorney, make sure you had all your legal questions answered?
Yes, Your
You
Honor.
understand you're waiving the right to go to a trial and
Yes, Your Honor.
agreeing to this. This is a little bit unique. I'm sure you've gone over it in detail, but I just want to ask you about it. You know, you're pleading to the bench. There is a cap on this, DOC. Now let me ask you this. This is an important question. The way it's framed is a little unclear. Point of clarification. Cap of 12.6 DOC
Months.
months. Well, no, that wasn't my question.
I think
Is it 12, you said that 12.6 months?
yes, sir.
Is it for each charge or?
It's concurring, Your Honor. Can I add an asterisk and write the word concurrent after DOC?
Yeah. I thought that's what it was, but it has to be made clear.
Yes, Your Honor.
Good catch. Of course. It's better to be in paper.
Y'all got that?
Okay, so as I said, this is a little bit different. The first part of the equation you're basically agreeing to. There will be an adjudication of guilt on these. You've agreed to that, but we're withholding on the sentencing until you get a chance to argue your case. Okay. We're going to get a PSI on this?
Your Honor, I wasn't requesting it on this one.
Whatever you all
We
think.
didn't see it as necessary. I didn't see it as necessary. He didn't.
Okay, very good. So we'll come back and when do we want to try and do this?
I think we have to consult with your assistant, Your Honor, to be
Okay.
determined.
Yeah, that's true. Yeah, that's right.
And Your Honor, this does need to, I'm sorry, Judge, should stand. It does need to occur in the afternoon
Yes.
because my victims will want to speak to the court.
Yeah, no, yes.
I
We don't
I
want to
already,
do sentencing in the morning.
I already know the court's going to hear from my victims, Your Honor, so
Sure.
you don't
No,
need me.
I don't, we always want to do sentencing in the afternoon. Okay, so based
Your
upon that testimony, the court will, like I say, adjudicate you guilty both counts. The one count will be dismissed in 676. Plea to the court, cap of 12.6 months DOC for each of the charges concurrent. So you can't really have any more than 12.6 months. There is no cap on supervision. I could say, come back and then go to some additional probation. Okay?
Yes, sir.
Thank you very much.
Thank you, Your Honor.
Larry Brown.
Your Honor, I've been in touch with the state on this one, but at this time, the state wasn't prepared to enter the agreement that I had proposed because of lack of victim contact. I think Ms. Sharpless just needed to make sure she got a call back from the victim.
Yes.
Is there any way we could pass the case to Thursday, August 22nd, Your Honor?
We can come in the afternoon. We'll continue until August 24th at 1:30.
Is it August 24th at 1:30, yes.
Correct, ma'am? Isn't that right?
Yes, sir.
50-minute contact is required. That's thank you. David Canmore? Your Honor, we have an agreement in Mr. Canmore's cases. I'm just making sure everybody's got a copy because it's pretty elaborate in terms of the number of counts and stuff.
Sure.
Ready to sign. Thank you. And I guess because there's not probation, I won't have to burden probation with a copy after also. And the state have a...
I'm sorry, Your Honor, I may owe you a score sheet on this one. This is another one.
I think I have an extra copy, ma'am, and you can confirm. It's what you send me. I just happened to print it out, an extra. May I have your indulgence, Your Honor, just to make sure the state that I have the right score sheet. That's the time that you're agreeing to.
That's correct.
May I approach with the score sheet, Your Honor, and the agreement? No. Thank you, Your Honor.
Thank you.
Your Honor, under this
An
agreement...
agreement on the score sheet?
Yes, Your Honor.
Okay, go ahead, I'm sorry.
Thank you. David Levon Canamore is resolving his 4 pending criminal felony cases in Okaloosa County as follows. There would be an adjudication of guilt as charged. There would be concurrent 61.05 months DOC with credit for all time served on felonies. There would be $515 times 2 court costs for the 22 CF 2533 and 22 CF 2534. There will be $967 in court costs times 2 and 22 CF 2635 and 23 CF 720. There would be a total of $450 public defender fees. Monetary obligations will go to collections 24 months after release. Time served on misdemeanors. And I do want the court to know that Mr. Canamore believes this is in his best interest. I did just very recently begin to receive large quantities of evidence from the 23 CF 720 case. I haven't fully gone over it and discussed with him, but my understanding is that that would not in any way change his desire to do the agreement today.
Got one issue.
Yes.
I'm going to take this for a second. The 61.05 exceeds the statutory limit on the five-year felony, so what you need to do is do 1 for the 15-year, the 61.05, and then the rest of them will be concurrent 60-month sentence.
Oh, I'm sorry, Your Honor, you're absolutely right.
Maximum you can be sentenced on the third-degree felonies. Third-degree felonies is 5.
So the
61.05 is 5 years, 1.5 months.
So the may I make the changes and then I'll re-announce?
Sure.
Okay, thank you.
Gets you to the same place. And it's the 6105, is that the guidelines, minimum
It
guidelines?
is, Your Honor. And I've spoken with all of the victims in the case and explained this, especially the victim's representative on this last case, and everyone was okay, and nobody stated that they wanted to speak to Your Honor before he was sentenced, so that's why we went ahead today.
Very good.
As for the first degree felony, 23 CF 720, what was the, what did you decide on that?
I've written it out, ma'am.
Okay.
We'll redo it.
I'm gonna read
We'll state it again.
I just wanted to make sure.
That's fine, go ahead. Oh, it's fine.
On F3s. Okay, those are third-degree felonies.
May I approach, Your Honor?
You may.
Rather than writing it out a bunch of times, I'm making a copy on the phone here.
Okay.
Your Honor, what I did was clarify and showed Mr. Canamore that the 61.05 months DOC with credit for all time served would apply in 22 CF 2533, which was a second-degree felony with a 15-year max, and in 23 CF 720 count 2 only, which was a 30-year first-degree felony max. And there's an asterisk after that, because at the bottom of the asterisk I put concurrent 60 months DOC on F3s, and then those are the 5-year maxes, and I put 4 asterisks on those 4 third-degree felonies, Your Honor.
Very good. Did I already swear you in? Did I swear you in?
I don't think so, Your Honor.
Would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
I know it's a little bit confusing, but try and make sure and break it out. He went over it in detail. So, just want to make sure you understand that essentially, to summarize it, you're being sentenced to 61.05 months. Several of your charges, actually 4 of them, 6 of them, have less maximums than that. So you can't be charged, those can't be concurrent. So they're doing the 61.05 on the 2 counts that are 15 and 30-year maxes, so the 61.05, those will be done concurrent. They'll also be concurrent with the other 4. They're going to be 60 months, which is 5 years. That's the max. And then the 2 misdemeanors, which are 1 year max, you're getting credit for time served. Those will go away. Okay? But it gets you to the exact same place, but just the way it was worded. Is that your understanding of what you're pleading to here today?
Yes, sir.
Okay. And you believe that you've read through the plea agreement, there's a lot of legal stuff in there. Did you go over it with your attorney closely, and did you make sure you had all your legal questions answered?
Yes, sir.
Has any of this, do you have any other questions based on all kind of some of this confusion that we have here? I don't want you to go back in the room and say, oh, I didn't I don't understand that, and then, you know, we'll be hearing from you next month.
Well, the only question I have is, if possible, if you can, I would like if you can grant me a 24-hour furlough so I can go and put some personal belongings in storage and I can turn myself back in. That's the only question I have, if possible.
Your Honor,
I would be surprised that.
I'm understanding Mr. Canmore is asking to get out for 24 hours?
Yes.
The answer to that would be no.
I anticipate it. And it doesn't hurt to ask, does it, right? Okay. That would be a big no. So, but anyway, so the other thing is you will have standard fees and costs. In Monterey, you'll have 24 months after your release to pay those before they go to collections. But you'll not be on any more probation, just straight serve your time and get out.
Yes,
Okay.
sir.
Any questions?
Yeah. Will I be able to go to a work release?
That's when you get to, that's up to them. That's not my, it's not something I do at this stage of this stage of the proceeding. I do have to tell you though, you do have 30 days to appeal this, even though you just entered into this agreement. You have 30 days to appeal it. Okay? Thank you.
Thank you.
Your Honor, I meant to speak with Mr. Thank you, Mr. Cameron. Your Honor, the state has made a time-served offer to Mr. Collis. He does have a pending Santa Rosa County-related appeal, is my understanding, that I'm not his attorney on, but could we return on the 24th at 1:30, August 24th, which would give me a time to try to talk to him on Wednesday? I'll do my best.
Very good. We'll continue this till 8:24 at 1:30.
Thank you.
That's Mr. Call.
Collis, ma'am. I'm sorry I did not state that. Madam Clerk, that was Christopher Deshawn Collis, docket 76, 22 CF 1271, 22 CF 1273, and 22 CF 3027. Your Honor, this is Jackie Colton. Mr. Colton is before the court, docket 77 and 23 CF 487. The state had given Mr. Colton what my understanding is the state's best offer would be for a lower charge. Is the state in a possession of any information as to gain time, whether that would be allowable if we were to take the state's revised offer?
After your inquiry, Mr. Medina, under 944.275, subsection 4E1, he would not be eligible for gain time with either one of the charges. So whether it was the original charge or this one, you would not be eligible, sir.
So now he's asking about, slightly rephrased question, but he's asking would the 85% apply? But I think that is what the state
Not gain time, but 85% was
No, it's day for day, sir.
100%?
Yes,
Day by
that's
day?
my understanding, sir.
Okay.
Your Honor, Mr. Jackie Colton, it's a very, I'm not going through the terms here, but it's a very significant issue as to the details I need to go over with him. Could he come back for plea or continue this jury review at 1:30 on August 24th?
Yeah.
Still not fast at 1:30, Your Honor.
What are we at?
When you have jury review in the morning at 9,
Right.
Either,
This will be in the afternoon.
Yes, sir, and I'll tell you how many you have.
A lot of these are real short.
It's going to be most likely.
These are all please.
All right. You're up to 7 in the afternoon.
That's fine.
Okay.
It's
Because
not
we got
gonna-
4 or 5 of them are just.
We're either going to do a deal or it's going to be continued, so.
And what will the offer open, just
You've
for
got
the
12 in the
record?
morning, and you've got 7 in the afternoon, if that helps.
Yeah, that's
Thank you,
fine.
ma'am.
Yes, sir.
See you then.
Thank you, guys.
Stanley Crowder. Your Honor, Steve Medina with Stanley Crowder. Mr. Crowder's cases are 23 CF 639, 23 CF 640, and 23 CF 631. The state is trying to get a hold of victims, and you still need a little more time on that?
Yes, there are several of them in this case, I think.
The state is asking to put this on the next available miscellaneous date so that it can have required victim contact.
September 12th, would that work?
Yes, Your Honor, that will work.
September 12th at 9 a.m. We'll continue this matter for a plea. Hopefully.
What happened? Coming back September 12th, the state has to have contact with the victims. It has to be. You're not getting the bond. It's not a bond hearing. That's what you're gonna come back. That's what they have to talk to the victim. That's what can you do, Keith? Thank you.
What about, just for, we have a non, Talal Donaldson? Is that on your document? Is that already continued?
I haven't seen him today, Your Honor.
Okay.
This is one
Didn't
where
want to skip over it.
Madam Clerk, the court is referencing docket number 80, Talal
Correct.
Tanwi Donaldson, 22 CF 1610.
Yes.
We had continued over to today a motion to relieve the public defender's office. I can represent, I've not been contacted by him in the intervening week, so there's not been a meeting.
What is the state asking?
Your Honor, the state would ask for KPS.
Granted.
Thank you.
Mr. Dumas?
And is that a no bond, Your Honor?
That would be a no bond.
Okay, thank you. Your Honor, I've been in contact with the state on Mr. Isaac Salame. How do you see your middle name? Salam, I'm sorry, sir. Dumas, in 81 docket 23 CF 1300. The state needs, Ms. Sharpless needs to talk to her supervisor about this one.
Okay.
Do you think we need to do a continuance to miscellaneous, or
Yeah.
is it one that we could do something quicker? Because he's got an acceptance that we've got the proof on.
I don't know how crowded the 24th is now versus
I
miscellaneous.
We
sure
can
like
still,
to-
we can do the 24th.
Yeah, let's try to do the 24th, because getting treatment for him would be
At 1:30?
1:30.
family. Thank you. All right? That's this Thursday at 1:30. You'll come back, okay?
Mr. Nigel Irvin?
Your Honor, Steve Medina with Nigel Nicholas Irvin. He's before the court, docket number 82, 22 CF 1639. And I've communicated with Mr. Irvin and with the state. The state's, it looks like the state and Mr. Irvin are going to be able to reach an agreement that would be non-incarcerative. There would technically be a 60-day new jail sentence with no credit, simply to make sure he was not put on the street while the interstate compact was pursued with the state of Pennsylvania. And so that would allow him to not be without a place to stay around here while that was going through review. if we can, I know we're loading up August 24th, but it's very important with him. I will get with him on Wednesday and make sure we go through all the details. Can we please continue him to August 24th at 1:30 p.m.?
Continue until August 24th at 1:30.
And, Your Honor, if we may, we've been speaking with probation parole. If Mr. Irwin could provide us the address of where he's intending to move to in Pennsylvania, then they might be able to start looking at some of that for him.
Yeah, that's no problem. I gave that to them.
We gave it last time and the time before. Could he repeat it? Could you repeat?
Sorry about that.
Is there any other information that might help?
Just have a document if he can sign it right.
What's it?
Okay, thank you, Your Honor.
They wanted to sign something, Mr. Medina.
Oh, okay. Can I just make sure I see what the document is?
Yeah, that's the application.
Oh, good, yeah,
It just
great.
needs to, you're gonna sign your name, print your name and date.
It's really nice of y'all to do that.
Yes, thank
So, Your Honor, just so the court's aware, the probation has kindly prepared his interstate compact application form, and he's signing it. Thank you for that enormous courtesy.
There we go. Yes, thank you very much.
Date on that.
Oh, date? 21st, okay. 8, right?
Yes, sir.
8/21/23, right?
Yes, sir. All right, I'll go ahead and witness it, and I'll give it to Officer Sheldon.
Sorry. Thank you very much.
Yeah, thank you.
Yeah, his marks
I know I've got 2 agreements to
According to
draft.
my list, Mr. Medina, you just have the 2 that we put aside.
Yes, Your Honor.
So, take a break.
Yes, if you don't mind. Thank you so much.
Mr. By, if you will let me know
Yes, sir.
when you're ready, and I'll come running back.
Yes, sir. And it will probably be better for the court if I did type it up. It's only going to take.
Burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Island's burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at DaysTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Background Bakery Cafe is 2 blocks from the courthouse on Crestviews historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boys Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648 North Wilson Street. Call 850-682-2446.
I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza, Stop by and let us help you be healthy.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared.